Hello, everyone. My name is Roger Colaizzi. I'm chair of the Venable's National Advertising Litigation Group. With me to my right is Ellis McKennie. He joined us in January of this year as first-year associate. And to my left is William Lawrence, who joined us the day before COVID started from a big law firm up in New York. And we've been working together for quite some time, and we thank all of you for joining us with our artificial intelligence and advertising presentation. And you can see our smiling faces on the screen as well, and please feel free to contact us. There'll be a slide at the end that has our contact information. All right, technology advances in artificial intelligence, and there's a definition up there on the screen. But one of the things that you really have to think about with artificial intelligence is that it's a system use, it's a machine use, but it's human based, and the inputs are to perceive real and virtual environments, abstract perceptions in the models through analysis in an automated manner, and uses models and inferences to formulate options for information or action. It's predictive, it's learning, it changes constantly, and we're in for quite a ride as we go forward, because from today to a month from now to 6 months from now to a year from now, the world will be very different as it comes to artificial intelligence. And as we think about AI, and we looked at the definition, or at least the working definition, there's no commonly accepted definition from a legal perspective or from a court that has identified one. But it's going to be important as we go forward, because it will have to determine whether there's a claim of AI use which is false or misleading or deceptive when it comes to advertising. And so when we think about AI used in advertising, there are many things like predictive analytics. And Ellis, if you could really talk about maybe the personalization or the predictive analytics of AI as it's used in advertising.
Absolutely. So the predictive analytics is what we most usually think of as the algorithm that we see in social media or that we see when we're browsing online. This is what allows companies and advertisers to target individual people and target groups of people to figure out what their preferences are, what their patterns are, what they're looking to do in the future. It can be very predictive in terms of predicting future actions. So for example, if you just bought a grill last week and now you're seeing advertisements for grill cleaner or the scrubs you can use on your grill, it's not by accident. These things are being tracked and they're being put together and then put into a model that allows these advertisers to make sure that you're seeing these certain ads that they want you to see. And as we're going to talk about throughout, this isn't a new concept, right? Developing your marketing groups and the consumers that you want to target isn't something that is novel in the 21st century. However, the ability of AI to do it dynamically, to do it quickly, to do it after you click backspace once to figure out now you're looking for something different, that is what AI technology is beginning to allow.
So it's really you can deliver an ad specific to just one customer, one individual.
Yeah, exactly. And you can also do it you can do it with segmentations and groups of individuals as well, and make it very personal and very direct to the person that you're trying to advertise to.
So what about chatbots?
So chatbots are interesting because chatbots have allowed companies to provide customer service a lot easier, but have also allowed them to advertise at the same time. If they have these AI chatbots that are available 24/7 and have the ability to respond to even more complex issues than they'd normally be able to respond to. And it also then allows them to advertise through the chatbots if you're asking specific questions that may lead you to a product that they're selling. And so these chatbots allow for more efficiency in the customer service and in solving complex issues, but it also can help convert inquiries to bookings or just searches into purchases and the conversion rate of a lot of these companies.
So back in the day, I mean, we had the customer services, and you'd pick up the phone and call and check questions or wanted information or wanted to talk to a live agent to really make your purchase, those customer service reps were there. And we often review scripts to as to what the customer service agent would say to the potential purchaser, because that's also advertising in a sense, and you know, make sure you weren't overreaching with the attributes of a product or a service, or what might happen, or what the customer could expect if they purchased the product. And so how is that different today, or is it even different? Do we have to, I mean, is there a way to even, you know, look at a script, or is AI just gonna take over and we're not sure what's gonna happen?
Well, I think it's all about the training of the models, what you're going to put in, and the input that you put in to decide how it's going to respond to the information that it receives. And I also think it's important to look at the programmatic element of it, that these AI models are getting so precise and so sophisticated that they're able to replicate regional language. They're able to discuss topics that are hot in the moment, or that are dynamic, or something that you just searched. And so it's not just a type in response type system, that they're actually, it's scary to think about it this way, but they are thinking. The AI gets what you're putting in and then figuring out the best way to respond to that. For example, if we're putting out ads and we're talking about people sitting around watching football together, you need to make sure that if you're sending that in the United States, it's one sport, but anywhere else in the country, you're talking about a different sport. And these AI programs, these chatbots are so advanced that they're able to fine-tune that even within the United States with different regional dialects and the way people talk about different products. They're able to decipher what type of customer you are, what you're looking for, and what type of ad is best going to represent with you.
Given that these chatbots seem to be kind of learning based on the prompts, and sort of taking it to the next level in terms of interaction with the customers and how they respond and what they're going to say, I imagine it's probably even more important to be very, very careful in terms of what you teach them. Therefore, you have to be very, very careful. Probably should have advertising lawyers advise you in terms of what sort of prompts you give them and how they're going to answer, and make sure that those answers are in compliance with advertising laws, and continue to test as it iterates and that sort of thing. If that kind of makes sense with where the technology is going.
Absolutely, and I think it's important. That's another crucial piece that we talk about later, is that the bias that they can develop, because they are human inputs that create these machines. And so the human element of it at the beginning, that has its own implicit and explicit bias, is going to be reflected then. Even though it is a machine and is not a human that has lived experience, the information that it gets has already been pre-selected in some sort of bias or some sort of decision-making capability. So you're exactly right. It's very important to monitor what you put in and what systems you're training your models on.
So some downsides too, I suppose. You've got, you know, up here, we're going to be talking about deep fakes and voice cloning and other transgressions that, you know, in-house counsel and outside counsel would say you certainly shouldn't be doing, and how we go about making sure that we don't end up creating advertising that is problematic, and how we do that. And I suppose it kind of starts at the top from the government, right?
Indeed it does, Roger. And Ellis, if you don't mind, why don't you tell us exactly what our government is doing to address all of these new artificial intelligence technologies that are coming out?
Absolutely. So like Roger said, it's going to start at the top. And so in October of 2023, President Biden signed the AI executive order, instructing the executive branch and agencies to take steps to implement AI into their practices, as well as create standards and monitor and regulate AI in their particular jurisdiction. The AI executive order asked agencies to designate AI agents within the agency to be the lead force to monitor and help guide agencies through this process, but also have instructed them to create studies and practice and a task force in order to figure out where AI best fits into their jurisdiction, both in their practice, but then also in their public-facing work. There were a few guiding principles and priorities of the AI executive order that can be applicable to us. It is to make AI safe and secure, to protect Americans against potential risks, like we were talking about some of the harms that AI can cause. It is to promote innovation, competition, and collaboration among the many AI tech companies, whether that's manufacturers and production in AI, but also with the implementation of AI machines in the consumer-facing products. The next two, supporting American workers and equity and civil rights, has to do with the governance and the social governance of AI, the real world impacts and harms that AI can have on people and the way that we can best protect the American public against some of those problems. Consumer protection, protecting consumers while ensuring that AI can make our lives better off, but at the same time, they're not going to begin to harm the way that we do business. Privacy. And then the last two I thought were interesting is they made a focus on AI and governance and AI and government. So AI and governance is actually the products or the services that these agencies are given to the public, making AI, finding the best way to use AI for these services, making the services more convenient, making them more flexible and efficient. But then AI and government as well, the way internally these government agencies can use AI to process their data or to make their own processes more efficient as well. So these were all the focuses that the executive order tasked the executive branch and the agencies with to study and to begin to promote throughout the agencies. And at the same time, the White House got secured voluntary commitments from 15 big tech companies to drive safe and secure and trustworthy development. Companies including Google, Meta, and OpenAI they signed on to promote and be a part of this task force to try to promote the safety and security of AI in an attempt to gain back public trust of a technology that to the average American may be pretty scary, and to some of us that we don't know exactly what's going on.
And although the government, of course, is coming up with new approaches and new laws concerning these new technologies, the FTC has been very, very clear that we should definitely not forget the old laws. From their perspective, they are particularly tasked with the enforcement and regulation of this new technology. But they said, although the technology is new, the rules of the road are old. The Section 5 of the FTC Act still prohibits unfair and deceptive acts or practices in affecting commerce. The FTC has been very clear that those laws do apply directly to AI, and there is no AI exemption from unfair and deceptive trade practices. Commissioners believe that they have all of the tools already necessary, even without new laws, to address all of the new technologies and all of the new issues, which we'll talk a little bit more specifically about later. And you just have to remember that the old laws still apply. And so we're going to talk about some applications of some of those old principles in terms of truth in advertising. We're going to talk about a new rule, the impersonation rule, that the FTC believes will apply directly and be very important in the enforcement of some of these new artificial intelligence tools that are coming out. But the most important thing is that we can't forget that advertising laws are still on the books. And as these new AI applications come out and as people advertise the great AI benefits to their particular products, they have to remember that they still have to follow the laws that are already available.
That means, as you know, that we're also going to see the states with their Unfair and Deceptive Trade Practices Acts. We know from the past that when the FTC brings a case, oftentimes you have one or more, all the states who join in with the FTC to go against bad actors. And so that, the Unfair and Deceptive Trade Practices Acts have the principles of both the FTC Act as well as the Lanham Act in trying to prevent deception to consumers.
Yeah, and as William said too, the FTC has been outspoken about they believe that they are the agency or one of the many agencies that can provide this enforcement element. They believe that it's already well within their power to enforce the AI. And one of their biggest guidances is that if you don't have to emulate human-like behavior, try not to, unless it's a necessity for your product, because that's one of the more difficult things when AI is being created that's undetectable from actual human behavior. That is what the FTC is looking for. So their guidance to companies that are trying to use AI, that is, it doesn't have to emulate human behavior, and don't make it one. But if it does, make sure that you disclose.
Right. And the whole concept of dark matters that the FTC is enforcing now is kind of almost wide open now with AI practices that either are intentional or unintentional as the acts come out. So truth in advertising. We know what the FTC mandates, we know what the Lanham Act mandates, and we know how state AGs operate in the other the states as well. And so when we think about this, the FTC Truth in Advertising, there's an attorney at the FTC's Division of Advertising Practices, and his name is Michael Adelson, and he wrote a blog about the ways to avoid making deceptive AI claims. And there are 4 of them. And the first one is, ask yourself, are you exaggerating what your AI product can do? And he says, we're not living in the realm of science fiction where computers can generally make trustworthy predictions of human behavior, right? And claims will be deemed deceptive if they lack scientific support or if they can be proven in specific circumstances that are marketed as broadly applicable. So as you think about what he's saying there, it's nothing different than what we've seen in the past. We have to substantiate advertising claims. We can't be deceptive with respect to advertising claims where we need scientific support for maybe direct comparative claims or superiority claims. We have to have it, or it's not going to be supportable, whether the FTC brings it and they say you have to prove it's truthful, or it's a Lanham Act case and the plaintiff has to prove it's false. You're still going to need that kind of substantiation. 2, are you promising that your AI product does something better than a non-AI product? And here we're talking about selling products or services that are purportedly AI utilized, or AI is utilized in these products. And so if you're saying that your AI product or service will continue to learn and give you better performance over time, again, you better be able to substantiate that. And you need the adequate proof for a comparative claim that says the AI technology makes your product better. And what Michael Addison said about that, he says, look, if your proof is impossible to get, then you probably shouldn't make the claim to begin with. 3rd, are you aware of the risks? And there are foreseeable risks of harm of the claims that your product makes. And like things, you can't go back and say, hey, this is really kind of black box technology, and we don't really have the ability to control what happens in that black box. And so we should not be held liable for what happens and what is spit out of that black box in the AI sense. That's not going to be a defense from the FTC standpoint. And it's not going to be an excuse for not knowing. And that's, we've seen that in, for example, like affiliate marketing, right? There was a time when everybody relied on the defense. Well, we using an affiliate company and they affiliate marketers themselves work for that company. We don't really know what goes on, and they say what they say, but we didn't approve it. And of course, there's a solution for that from the FTC standpoint, as well as in the Lanham Act category as well. And that is that you are responsible and you have to control, at least contractually, and monitor the affiliates. Same thing here. You have to control what your AI product does or doesn't do, and you can't rely on ignorance as a defense. And that's standard in all cases, but it's really relevant here where that defense has worked in the past, such as in affiliate marketing. It's not going to work here from the FTC's perspective, at least. And lastly, does the product actually use AI at all? And again, we kind of think back when you say, and just for as an example, when you say something is AI enabled, that means that you're telling a consumer that, hey, this is going to be a learning tool from a computer algorithm standpoint, and it's going to get better the more you use it and the more you input into it. And maybe your product doesn't actually even use AI. And if it doesn't, you can't call it AI. Just because you use AI to advertise your product doesn't mean the AI is in your product. So think about that when you're making a claim that your product utilizes AI. Again, you got to go back, you got to prove that it actually is using AI.
That's a good point, Roger. And we're talking a lot today about sort of what laws are coming out, what regulators are doing, what the government is doing. But we have to remember that in advertising these products and beginning to tout the benefits of some sort of AI application in your products, you also are going to be dealing with your competitors. And that's what Roger keeps referring to when he refers to the Lanham Act. The Lanham Act still will allow your competitors to sue you over any misrepresentations concerning your products. And therefore, these rules are also good rules to follow to ensure that the people that you're competing against don't have reason to send you cease and desist letters, don't have reasons to challenge your advertising, don't have reasons to sue you in court, because the AI benefit that you're claiming your product has is really something that is not really an ongoing AI benefit. Maybe you used AI to actually create it. Maybe, as Roger said, you used AI to advertise it. Maybe there's some AI component that enables the product to work, but it doesn't actually make your product better than your competitors' products. And that's where your comparison and substantiation come from. If you're comparing your product to someone else's and you're saying that the reason your product is better than your competitor's product is because of AI, you better be able to substantiate that. You better be able to show scientifically why there's some sort of advantage to your customers over your competitors' customers because of AI and not because of some other reason.
Yeah, and I think this also, this truth in advertising piece leads us back to kind of what we talked about in the beginning about a working definition of AI and the way that that is continuing to change as the technology progresses. Because one could argue that a simple analytics or a data chart or a data set that's going to give you predictions could be AI, but the FTC has spoken that simple analytics aren't going to be enough. You can't just say you have AI because you have a simple method or a calculation that you make that is automated. You know, we're going to have to see as time goes along how the definition of AI and what AI in a product actually looks like. So the next part of the FTC's regulation of AI is the FTC impersonation rules. So if you actually look at the language in the rule, there's very little that actually says artificial intelligence or AI. The FTC finalized a government business impersonation rule, allowing them to file cases directly in federal court, aiming to force scammers to return money they may have received from impersonating the government or other businesses. But the rule was promoted and pushed so heavily due to two factors. One was the AMG Capital ruling, which made it more difficult for agencies to require defendants to return monies they received from some of these scams. But number two is the accelerating AI technology. The FTC and its commissioners have spoken often about this rule, that the acceleration of the techniques scammers use to defraud customers have made it difficult to detect, and that they need as many tools in their toolbox as possible in order to regulate and enforce these issues. And so, like we've been talking about, this rule targets acts that are already illegal. It's already illegal to defraud customers. However, AI has made it so easy and so dynamic and so efficient to do it at a wider scale and a much easier way to do it, that you need these types of rules in place so that we have lawmakers and regulators that are able to take on this challenge. For example, the FTC gave 3 examples that they're specifically looking to stop, and that is using government seals or business logos when communicating to customers by mail. AI models can very easily shift these logos a little bit or be able to implement these logos onto what may look like official documents and be undetectable. Spoofing government business emails and web addresses. So switching, you've all seen emails where they switch one letter so it looks like the official email, but it's not actually the official email, and are then tricked into sending money or sending information. And like I said, this isn't a new tactic, but AI allows you to do it at such a broader scale that enforcement's so important. And then finally, falsely implying government business affiliation. So we're going to talk later about fake robocalls or voiceovers where you say that you're part of a government agency or that you're coming from the clerk's office. And so the FTC is seeking to expand this protection as well to individuals. So this is one of their tools that they're looking to regulate AI with. And then next, going to the Elvis Act and the state patchwork law. So Roger let me present this one because Elvis is kind of close to my name. So that's what we were doing here. So there's a lot of state law patchwork, and I highlighted 3 specific areas that are more relevant to us. Tennessee obviously is the home of country music and the home of a number of music industry organizations. They passed the Elvis Act, which is the Ensuring Likeness, Voice, and Image Security Act. And the act updates Tennessee's protection of personal rights law to include protections of songwriters, performers, and music industry professionals' voice for misuse by artificial intelligence. And this simply supplemented a pre-existing name, image, and likeness law that did not specifically address generative AI cloning and now allows you to take action for this type of offense. And this type of fraud has always been present in the advertising industry and in the music industry. This isn't anything particularly new, but now companies are trying to use AI as a tool and almost as a shield that protects them from it. And Tennessee is a state that said this is something that you're not allowed to do, that cloning or duplication of a musician's voice and their right of publicity is against the law. Next, we've got the state political ad laws in 2024. Obviously, we have an election year and states have been focused on this. We've had 16 states pass laws regarding the use of AI in political advertising. The vast majority of them are disclosure laws that require, if you are using AI in a political ad, to disclose that in the advertisement. While there are a few states who are actually prohibiting the use of AI in political advertising. And this actually raises a number of other issues, including First Amendment issues, where who is actually in charge of pulling political advertisements and censoring this type of speech? And what type of restrictions are we going to be able to have on political speech, whether it is AI or not? I have a feeling that's going to be a hot topic over the next couple of months and in the future years around election times. And then the final one I wanted to highlight was the California chatbot law. So this law made it unlawful for any person to use a chatbot to communicate with a person online with the intent to mislead the other person about its artificial identity. And so the purpose of this law is to, as the FTC talked about earlier, is to prohibit the use of AI technology that's trying to emulate human behavior and defraud customers thereof. So that you know that you're talking to a chatbot. You don't think that you're talking to an agent on the other end. You don't think that you're talking to a human being, that you're aware that you're talking to an algorithm, and that can allow you to make your consumer decisions a little easier or differently compared to if you were talking to a real person.
And I think it's important to note that once again, just like the federal laws, these state laws are really just codifications, extensions, clarifications on concepts that have existed in state law for a while. As Roger said earlier, the Unfair and Deceptive Practices Acts, which are we call the mini FTC Acts, which parallel Section 5, generally usually prohibit any sort of misleading, deceptive acts or behaviors as it relates to consumers. And these laws are sort of being very specific to AI, but those laws are already on the books and the rules of the road there are already set.
But also, protecting rights of publicity, as Ellis said. There have been cases and cases on that over the years in advertising under the competitor where you see one suing the other for using the voice of the other's spokesperson, so making it look like they switch sides. And this is very effective when it looks like the top competitor now, the spokesperson's on the other side. At least that's what it sounds like. And those are the types of things that you might have in the past seen TRO or a preliminary injunction to stop that kind of conduct. Same things here. I mean, you can still use a TRO and a PI to stop that kind of conduct. But as you see states and the federal government codifying these laws, it's an important thing, and also kind of an indication of where AI might be going and how difficult it may be in the future to prevent it as AI starts learning more and is easier to defraud not only you who are trying to put together a fair ad, but also consumers who actually see that ad.
And so now, I don't think our presentation will be complete if we didn't give you some concrete examples of how this is starting to shape up. Now, as we have been talking about, this is pretty new technology. Laws are just coming out. People are just figuring out how to address it. So there aren't a whole lot of cases yet in terms of what happens when people may be kind of crossing the line in terms of their advertising and AI, but we tried to collect a few examples so you can
before we
see
do
practically.
Before we do that, we're going to give you the CLE code, which is Intelligence 2024. Intelligence 2024. We'll give it to you again at the end. Sorry for interrupting.
No, it's fine,
It's
Roger.
probably more important.
We know what people are really here for. So we just want to talk about a couple of cases brought by some regulators that we've seen so far, still early days. These really have to do with the concept of what we call AI washing, and we sort of have alluded to it, but an official definition is for disseminating advertisings that included untrue statements of material fact or otherwise omitted material facts necessary to make the advertisements not misleading under the circumstances. And so this goes back to the idea of if you're going to begin to promote your particular product, saying that it's better or more effective or gives your customers some sort of benefit because of AI, you better be able to substantiate that. And we see a couple of companies that have already gotten in a little bit of trouble because they didn't quite walk that line as finely, at least in the SEC and the FTC's opinion, as maybe they should have. The first two companies are Delphia and Global Predictions. They settled with the SEC recently. And essentially these companies were investment companies that claim to give their customers an unfair advantage over other competitors because of their use of artificial intelligence. They ended up settling with the SEC for $225,000 and $175,000 respectively. And then a slightly bigger settlement brought by the FTC is Automators Automators AI. Automators AI, this is actually a company that essentially was selling success in automation of stores. And so they were telling their customers that they had pretty much an AI functionality that would ensure the profitability of their online stores that they could kind of automatically set up and run for customers. FTC found that those representations were not necessarily accurate, and so they ended up settling for $21,765,000 in that case.
Just a little bit more.
Just a little bit.
So we included this case. It's a class action case brought by a few actors that I thought was very interesting, especially in the way that they were deceived and then the way that they found out about the alleged deception. So according to the complaint, these two actors were tricked into selling their audio recordings online through the app Fiverr for what they thought were radio hits and research. And in the case documents, they allege that they asked multiple times they were contacted by an individual who said, hey, can we pay you $1,200 for a few video recordings that we're gonna use for language research and things of that nature. And as it turned out, this anonymous individual actually worked for the company Lovo, and it is alleged that they worked for the company Lovo. And Lovo is a technology company with proprietary software driven by AI with which they create voiceover narrations adapted from real actors. So according to the complaint, Lehrman, who is the named plaintiff in this case, discovered that his voice recordings that he had recorded thinking he was giving them to research, he discovered them when he saw a YouTube video promoting Russian military equipment and heard his voice being the voiceover that was giving the information about that advertisement. And so he heard this and then again heard his voice again on a podcast discussing the dangers of AI technology. So that's where he heard his. And then the second plaintiff in this case, whose last name is Sage, she was similarly contacted on Fiverr for radio ads, but there's the picture in the bottom right here, where she found out that they were using her voice in investment pitches and had transcribed her voice and put it into the AI algorithm to do a number of different things for advertising purposes. So the plaintiffs brought a class action suit against Lovo alleging 8 claims, but including New York civil rights law claims for misappropriating an actor's voice for advertising purposes or for the purposes of trade without consent. And then also consumer protection from deceptive acts and privileges in the New York General Business Law. The actions and practices alleged herein were directed at consumers who wish to utilize the services of established voiceover actors or purely AI-generated voices and thought they were getting those services in an unauthorized and affordable way. So this is just one of the dangers of misuse of AI technology and advertising that can find a company like Lovo in trouble. And now the actors are seeking damages of at least $5 million.
So now another segment here. We wanted to just highlight some, not actual cases and no actual liability as of yet on any of these things, but we actually have seen, these issues popping up in the news. And earlier we talked a little bit about the issue of deepfakes and voice cloning. And for those of you who are not familiar, deepfakes is a concept where someone can use AI to digitally manipulate videos, images, audio clips to create a convincing fake piece of media. Oftentimes it's used in the news, sometimes it's used for scams. In this particular instance, something like that was used in what we would call a rap beef. And between Drake and Kendrick Lamar, I don't know if you guys caught the Kendrick Lamar concert last night, but in this particular case, what happened was Drake, a famous rap artist, actually cloned the voice of Snoop Dogg and Tupac to make an album which essentially was an insult song towards Kendrick Lamar. Tupac's estate did not look kindly on using the deceased voice of Tupac to make this song, and so they resulted in them sending a cease and desist to Tupac's estate and the song being taken down off of YouTube and the internet. Another interesting bit of news actually involves OpenAI, who we know is the creator of ChatGPT, which is probably the most famous at this point AI search engine, AI application. And they actually got in trouble because they used a voice for their recent rollout of their AI assistant that sounded eerily like Scarlett Johansson's. As you may remember, Scarlett Johansson actually starred in a movie where she actually played a sentient computer, AI robot that actually, sort of became human. But essentially, the founder of OpenAI has said publicly that he is kind of inspired by that movie and influence on him. And they actually reached out to Scarlett Johansson and asked if they could use her voice. She said no. But somehow when it came out, it sounded like her voice. OpenAI has said that in fact it was a voice actor, etc. But at the end of the day, Scarlett Johansson's camp took issue with this, and it ended up also being removed. So the last one is a more serious one, really. Lingo Telecom actually sent AI-generated robocalls mimicking President Biden's voice. And in the midst of this very, very contentious election, you can see how serious that may be. The company there is now facing fines from the FCC and state criminal claims.
I think these ones are interesting too, though, compared to the last case we just looked at, because they weren't deceived in any way into giving their voices. All of these voices are in the public domain, right? Tupac has a ton of songs out. You can find an interview or a speech from Joe Biden and put it into your algorithm and have it spit back out to you a fake voiceover for it. So that's a serious danger when you have a technology and you have these public figures who could be negatively impacted from it.
Yes, and as Roger was kind of alluding to earlier, the concepts for these aren't really new. I mean, cloning someone's voice or using a recording of someone or even using a double in a commercial.
Using a voice actor for sure has been used quite a bit in the past, for and obviously litigation has been brought as a result. And so you're always, I think now with AI and how the state and federal governments are looking at the easier way to use AI to deceive consumers, that is even more, although it does codify the rights of publicity for famous people and even less famous people, individuals in some of these states are protected as well. It is still it still is against the law, and it's still a pretty big deal for those people whose voices are utilized, and it is unfair advertising, and it's the laws that stay the same as you pointed out at the beginning, and you're still going to have to be held responsible for it if you improperly use it.
And this case is one of my favorites that has come up. In the Southern District of Illinois last November, there was a case that actually was one of the only cases that I've seen where a real lawyer actually sued a company that claimed to have the world's first robot lawyer. And this robot lawyer claimed to essentially offer an online subscription service, which would do your divorces, which would do your parking tickets, your speeding tickets, and all sorts of cease and desist letters to all of your competitors. Whatever you needed, they could seem to do, all using the power of artificial intelligence. An actual law firm in Illinois took issue with these claims, particularly because Of course, a robot, as of yet, cannot be barred in the state of Illinois. So representing yourself as a lawyer is false advertising. At least those were the allegations from the actual law firm. The result of this case is not as interesting. The court decided that the plaintiff actually did not have standing because they did not properly allege injury under the Lanham Act and under Article 3, and because the parties, according to the court, were not direct competitors, because apparently a robot lawyer as of yet cannot be a direct competitor of a real lawyer. This case was dismissed. But just interesting to see how these issues are really starting to come out. It wasn't as much of an issue in this case, but of course there are always going to be questions of how much does artificial intelligence really help in the type of work that this online subscription service was doing? How far can someone go in terms of claiming to offer legal services through these new artificial intelligence applications before they start dealing with issues such as actually being barred as a lawyer? These are the sort of things we're starting to deal with, and especially as actual legal tools, as we'll talk a little bit about later, begin to present themselves in our industry. We're also dealing with those issues in terms of our own professional work and, of course, serving you all as our clients.
And so then going to proposed legislation, in 2024, 40 states have introduced AI bills with 6 passing substantive legislation. But for the most part, for what we're focused on here today, many of them don't have a major impact on advertising generally. Much of the legislation has been focused on data privacy and collection and things of that nature. And then additionally, Congress has introduced dozens of bills focused on AI issues, ranging from system evaluations to labeling requirements or creating regulatory authority. But like I said, again, those have been a little bit farther away from the advertising space. However, I wanted to highlight the No AI Fraud Act. This was a bill proposed in the House, sponsored by Rep. Salazar and Rep. Dean. And this is a act that is more or less creates a federal property right for likeness and voice. It reaffirms that everyone's likeness and voice is protected, giving individuals the right to control the use of their identifying characteristics. This also makes it clear, if this law were to be passed, that a disclaimer for using someone else's voice without their authorization is not a defense to unfair use of their voice. They discuss how when someone's voice is used, the relevance of the primary expressive purpose of the work, and whether the use competes with or otherwise adversarially affects the value of works owned by the rights holder. So this, getting back to it again, is almost codifying the right to publicity. That's what the impact of this act would have if it were to be passed. But I do think we are likely to see more action in the states as opposed to in Congress on this type of issue, as it'd be a little bit easier and quicker to get it through that direction.
This also proposes specific fines per use, back up a second, for violation of this proposed act.
Right. So for AI duplication services, you could be subject to $50,000 per violation, and creations using unauthorized material could be subject to up to $5,000 per violation if this act were to be passed.
And as I alluded to earlier, every day there are new AI tools coming out, including in our own industry. And this is not necessarily new to law. We've been using different types of tools concerning like document review in terms of predictive coding, working with algorithms to enhance our efficiency when reviewing large numbers of documents on behalf of clients, to the extent that they want those services to hopefully make the document review more efficient and of course more cost effective. And we've been working with those programs and balancing, using the technology as a tool, using it for efficiency's sake, but not allowing it to affect the quality of the review and ultimately the responsibility of us as lawyers to ensure that everything that we submit to the court on behalf of our clients is absolutely correct and of high quality. But these things continue to pop up, and we are continuing to evaluate how we're going to use them. I think Ellis is going to give us a little bit more in depth in terms of some of what those things are.
Right. Yeah. So for example, there's the Case Text. Case Text is a website and an AI-powered research platform that allows you to use plain language questions. Like, as we know, as attorneys now, we're very good at putting the words we're looking for in quotations with our and what we need to be near within 5 sentences or 5 words of X. Whereas case text allows you to type plain language into the search engine. You can ask your specific question. I'm looking for a case that says this in this jurisdiction with these facts. And then case text through its AI-powered engine will then look and find cases that are helpful in answering that question. And this is obviously, it could be an extremely useful tool in terms of efficiency and productivity of attorneys, but I think it comes with its warnings of misuse again, where it's great to have this as a tool to get to these cases or to help find some of these arguments, but on the back end, you still need the human element, the human attorneys reviewing and going over some of this stuff. We've got Co-Counsel, which is an AI legal assistant, Lexis, which provides interactive searches, summaries. I thought an interesting one is Blue J and L&E, which is one for US tax law. It's a specialized AI platform, and it attempts to predict outcome. You take certain tax positions. But like, again, this AI tech it saves time. It allows us to be more efficient. It can be productive tools when used correctly.
And the use of these tools is both highly fascinating, but also terrorizing, because there's so much out there that can be done, and so much out there that we have to look at to make sure that these tools are not used improperly, that we end up with the correct result, that what we are saying to a court is truthful, not made up. All of those things come into play. But just as an example, you might have a question from an in-house counsel, and the question has to do with how do I protect against a Lanham Act claim or a TRO, and you might then come up with 6, and this was an example that was used by someone when we were talking about AI. And there are 6 elements that you have to meet, and then since these 6 factors, you want to explain more to the in-house counsel. So could you, AI, please expand on each of these 6 elements? And then you get a very quick response, just expanding on those. And then you might ask AI, can you provide cases supporting each of these elements? And you do that. And can you provide opinions by judges in these particular circuits relating to this issue? And AI does that immediately. And now you've got a pretty big memo that you put together in a few minutes that you now are providing to the in-house counsel. And they get it, and they're very well prepared to talk to the CEO, and they appreciate it. You put all this together for them, but they can't give this to the CEO, so they go to AI and they say, AI, can you please distill this into 6 points? And the amazing thing is that you start with 6 points, you end up with 6 points, and all the information in between is very important for the attorneys to know what kind of arguments to make to a judge. And I think, some people might say the ultimate outcome of AI for lawyers is just going to be where you've got robots standing in a courtroom talking to another robot who's the judge, right? And you just follow the precedent, and that's going to be the law. But we all know that's not the case, because you have splits in circuits, you have splits in courts within a circuit, and you have differences of opinion, and facts vary slightly, more or less, and laws get changed to deal with of the population as it happens to be, at this point in time versus 50 years ago versus 50 years in the future, right? So AI is really important, and it is very fascinating, but the level of responsibility that we have when we're using it, and that our clients have when they're advertising and using it for advertising, still have to comply with the laws on the books, and they're not going to change. It's going to be more protective of consumers than I think what we're seeing now, just because of the power of AI.
And just so we can talk about where we are now, we are certainly not to the point where the robots can stand up for lawyers right now. In fact, some attorneys if you may have heard, have been getting in a little bit of trouble using and depending on AI a little bit too much. We have a famous case where a lawyer used ChatGPT to write his entire brief and ended up citing a bunch of fake cases. If people are not familiar with the idea of hallucinations, it's this idea that when you give a prompt to something like a ChatGPT, some of the information that comes back based on the vast amount of information that it's been collecting from different people and putting together, and the algorithm will run, and sometimes you'll get information that just isn't true. So in this particular case, this lawyer actually cited fake cases to a judge, and the judge called him on it, and he stood up in court and tried to blame it on someone else, and got in a fair amount of trouble over it. In another case, the same sort of thing happened. Steve Cohen's attorneys used fake cases in a brief to end his supervised release. So these are still very real issues. Technology is still very new. The technology still has flaws, and particularly as we look at using all of these tools in our legal profession, using all these tools on your behalf, we're here to make sure that the tools help and don't hurt the clients. And that's probably going to be a general theme for AI as we're going forward. We need to be very, very careful that it's always being used to help and not hurt. And I think that's what regulators are focused on. That's what we're focused on here as well.
We actually have a couple of questions.
We got a couple of questions on the chat. This one's a good one. She asks, many AI applications with chatbots designed for customer service typically have a transfer to live agent during the interaction that is triggered if the conversation with the chatbot gets overly complex or for validation or acceptance of an offer. I'm curious if the subsequent conversation with the live agent is regarded as the sole basis for determining whether a UDAP violation has occurred.
Yeah, so I mean, I'll take a stab at that. If you think back to when there were only live agents, whatever the live agent said is going to be criticized or attacked if it is misleading or false or provides attributes of a product or service that aren't supported, aren't substantiated, aren't true, right? You're still going to have that aspect. And it's not going to be the agent to determine that they're looking to see if the chatbot did it the right way. I think it's going to be on the company to make sure that the chatbot, before the agent gets on, is providing a response that's going to be useful and more importantly, truthful as it relates to the pitch, if you will, to the potential customer to buy the product or service. So it's not going to fall to one person, if that was the question, but it's going to be the responsibility of the company and how the AI is used. And if you think back a few slides, you can't say, well, we did the best we could, but there's this black box and the chatbot said something that was wrong, and maybe the agent corrected it, maybe it didn't happen. But I think as you think about what you're trying to provide to customers that are yours, and you're trying to maintain those customers, which through AI and other tools has been better. The customer service aspect and the customer retention aspect has been way better than it has in the past, because you now have the information and the tools to better serve that customer, keep them as a good customer. So all of that fits together. And I think maybe the too long of an answer to your question is the company's going to be responsible, and you got to make sure you have the safeguards in place and constantly checking, just like these cases. You can't use fake cases. You can't use the black box defense, and you're going to have to just, make sure that you're doing it right.
Yeah, I think that's right. I mean, I've had some experience already with this, and it's an interesting question because, and this gets to what Ellis was talking about earlier in terms of actually getting definitions of what qualifies as AI. I mean, there have been chatbots around for years before AI. The idea of synchronous versus asynchronous communications with customers, this idea that when you call and you get sort of the recording with all the different prompts and you press 1 and you press 2, those things have been around for a while. And I've already had cases where there have been issues with the inputs of those communications, where the scripts that are created for those communications actually have misleading statements in it. And it doesn't really matter if the person is saying it live or if it's a recording or if it's some sort of, machine that responds to a prompt. If it's untrue, it's untrue. If it's misleading, it's misleading. And if the company is responsible for that communication to the customer, then they will be liable under Section 5, under the Lanham Act, or under UDAP laws. So I think the answer to your question is absolutely. If the chatbot says something based on the company's prompts that is misleading in advertising context, there is liability there.
So we've got another question here. It's a bit more IP related, but I figured we could pose it. It says, when using AI to prepare creative assets, do you have any guidance on how to ensure the source of the intellectual property used by AI is cleared, licensed?
Well, I think there's kind of two questions in there. One is when you're creating with AI, a big question is what is the AI tool that was used to create it, right? You think about, maybe a patent, right, that you're trying to create, and you get this idea, whether it's an invention that you have now or whether it's not an invention because it's AI created. You come to a point where, all right, you've stolen that idea, or you've gotten a patent, and now, or you're trying to get a patent, or you're making claims that actually are patent infringement, right? Because you're trying to create a product that already has a patent, right? And the same goes with trademarks or copyrights. It's going to depend on what your AI process or basis is, whether your AI tool is utilizing a way to prevent you using trademarks that already exist or that are confusingly similar to trademarks that already exist. And one of the things that we were talking about before we started this presentation is, can you ask AI to look at your advertising and tell you whether your advertising is lawful, right? Can AI actually go out and see if the advertising is truthful as to whether your product is twice as fast as the competitor's product, or twice as good, or superior to all other products on the marketplace? I don't know the answer to that. Maybe someday that's true, but at what expense is, are we now giving property rights based on AI to somebody who came out with a product? And when you think about the Lanham Act, which promotes competition, even if it's close, is it too close to be infringing? All of those things come into play. I don't know that we have the answers to that yet. So maybe that's kind of my stab at responding.
I would say that in terms of ensuring that whatever comes out of, ChatGPT or whatever you're using, you have to do the same sort of checks that you would do either way, whether the, output or the material is coming from Google, because you did a Google search and you found a great image and you want to use that image in some sort of compilation artwork that you're coming up with, or you're coming up with some new word that you want to brand. Like, you do sort of the same checks. Like, you get an image on Google, then you got to check to see where the image came from, and you got to check to see whether there's a copyright on the image or whether there's a license or whether it's free to license. Also, if you're looking at trademark, that's what sort of trademark searches are for. That's what trademark infringement lawyers are for. You can actually go and search to see if it's something that's available and you can actually use. When it comes to patents, it's both probably more complicated and easier because you have to actually submit for the patent.
Before we get cut off.
Oh,
Yeah, 359.
Oh, sorry.
The CLE code is intelligence 2024. But go ahead.
Intelligence 2024, then you actually have to get a patent on it, and the patent office does its own checks and cross-checks your prior art and all those different things. So the idea is kind of what we've been saying the whole time. The rules of the road are the same. No matter where it comes from, you have to do your due diligence to make sure that you're not violating any laws.
That's a good place to leave off.
I think so too. Well, thank you everyone for joining us.
And if you have further questions, please feel free to reach out to any one of us or all of us, and we'll try to respond to you quickly.